All right. It's 2 minutes past 4:30, so I think we should get started. Good evening. Welcome everybody to our latest chat or our webinar on data protection and privacy. Data protection is probably the buzzword of the times we live in, primarily due to the rate at which technology has seen rapid growth. Governments around the world have adopted different methods of regulating and protecting personal data. Today, I have a guest who has seen the change happening up close, as well as possibly being part of the change himself. If there was a rock star equivalent in the world of technology and data protection, it would have to be Rahul Martin, partner at Trilegal's Bangalore office. Rahul, welcome to our webinar. Delighted to have you join us today. Thank you so much for making time for today's chat. Can you all hear me, Rahul?
I can. Thank you very much. That was a perhaps more than generous introduction and welcome, but very glad to be here.
Terrific. Thank you so much. And one aspect that I forgot to mention as a part of Rahul's introduction is that he has also written a very informative book, Privacy 3.0, Unlocking Our Data-Driven Future. I have read this book actually twice, cover to cover, and I can tell you that if you're looking for something like a Privacy 101, to get started, look no further. This book pretty much gives you everything, the history and where we are today. So terrific book, Rahul. Really enjoyed reading this. Is this something that, I'm curious, I've never written a book. So how long does it take to research and write a book like this? I mean, it's very, very informative.
I mean, look, as you say, I've been doing this for a long time. So a lot of this, in a sense, resides in my head. So it's just a question of getting it out. So I guess if you were to start from scratch, it would perhaps take longer than it took me. But I'm going to say it took me roughly about 6 months to put this together. That's coming on the back of maybe at the time probably 10 years worth of working in this space.
Understood.
And as you said, a good part of it was, reference to some history. I was fortunate enough to be part of some of that. So that bit was a lot easier to write because it was just sort of more on the personal experience. But I thought that was also relevant, given that this book was placed in the Indian context.
Very much relevant and very, very interesting, actually. It's a very easy, breezy read. It wasn't too heavy. I think that's really what made the book very interesting and a very, very good read. And you said that you have another one coming up. Can you tell us a little bit about it?
Yeah, so, I think I wouldn't say that it's the next step to this, but, a lot of what I talk about in the book around, the fact that we are now getting into a third era, as it were, of data and the use of data. And that we need to think differently about how we regulate and govern data in this current framework. So this book sort of situates itself there, and it's focused on India's approach to digital public infrastructure and how within that there are some solutions perhaps to some of the challenges that the world has been grappling with in regulating data. So it's a little broader than privacy because the data governance challenges that the world faces also includes things like consumer protection, competition, all very relevant for companies, but slightly broader in aspect than what the first book covered. But this book, in a sense, goes a little further and talks about how some of the things that India has built could be solutions for the rest of the world.
Terrific. Looking forward to it, actually. Is there a timeline for when this is coming out?
As soon as possible, really. I mean, some of these things are, once you'll find when you do write your book, Anthony, that once you've written it, then a lot of it goes out of your control and it's up to publishing schedules and editors and all sorts of things.
Fair enough. All right. So whenever it is out, it is out. So I'm definitely picking up a copy. That's for sure. All right. So let's get started, Rahul. You've been in this space, technology and a privacy lawyer. I think you've been doing this from a time when probably nobody else was even thinking about it, right? I mean, a good 25 plus years ago, would that be right?
Yeah, I mean, actually, what you omitted to mention, and it's not your fault, is that this is actually my second book. The first book I wrote was called The Law Relating to Computers and the Internet, that was published in the year 2000. And to the best of my knowledge, that's the first book on the subject written in India. So that book took a little longer for me to write. I think I probably took 2 years to write that book. And so that sort of dates my interest in technology and technology law. So I've been looking at issues in the space for at least that long. And I continue to do that, and I find that really interesting. It's a unique sort of set of circumstances that you've got to consider.
So Y2K onwards it's an easy way to remember when your interest started or thereabouts.
Though I have to say that Y2K, even though it consumed a fair bit of my professional life in those early days, it was not really. I made no significant contributions to the jurisprudence around Y2K, as it was, because it was a bit of a damn squib.
It was a damn squib, actually.
Planes would. Yeah, people thought planes would fall out of the sky and nothing happened.
Nothing
whatsoever happened.
So how did your interest start in this field? I mean, how did this happen? I mean, is it that you had an interest, or you found this area interesting and therefore wanted to make this your area of practice, and then one thing led to another? Is that how? Can you tell us a little bit more about it?
Yeah, look, I mean, I think at the time, and perhaps even now, a lot of people think of technology law as just some specific aspects of law that technology companies will consult on. And so most of the treatment of this is very, very much just law focused. So contracts or data protection or things like that. But I've always believed that the only way that a lawyer can truly contribute to technology law is if you actually, as a lawyer, understand the technology that you're looking to guide clients on, and as you're writing policy, looking to regulate. And so I guess my interest in this was because I was always interested in technology. And before I went to law school, it was at a time when computer and computer science was not really as popular as it sort of got a little later. But I was always keen on it, not just for gaming and things like that, but for I would say very basic coding type things. And I think by then already I had learned a little bit how to code. I think my first and only job had one computer in like the fax room, and after everyone left, I connected that to a modem. And this is before the internet in India, so we connected to what was then the internet, which was a bulletin board service here in Bangalore. There were 2 BBSs filled with geeks, so I used to dabble in that. And the internet was so difficult in those days that you really needed to know some intricacies of coding and just figuring out how things worked. And so, I just, by virtue of having to learn how to navigate those spaces, got an understanding of the guts of internet and technology. And I think that's why. I mean, I liked it, I enjoyed it, and then I found that I had a bit of a aptitude for it. And then I think more importantly, I realized that clients really appreciated this because I could, very quickly talk directly to the engineers as opposed to speaking only to the legal department of the organization. And then I guess the most important thing was, this whole technology thing actually took off, and now technology is everywhere. So I don't think there's an aspect of law or society that technology doesn't touch, and so it became a really interesting space to operate in.
So sort of being at the right place at the right time, in a sense, what you picked up as your practice area turned, or hobby or area of interest, ended up being something that really exploded.
Very much so. Very much so.
Sorry, there was somebody had raised their hand for a question. If I may request the participants, we'll take questions at the end so that we give, there is sufficient time for Rahul to cover all of the areas that we have that we intend to cover today. So please allow us time till the end of the session, and we'll take as many questions as we can. All right, Rahul. So coming back to the topic, could you share with us how you've seen the evolution of sort of the regulatory framework in India? How has that evolved over time? And also, if you can sort of just give us a comparison in terms of how the regulatory framework in India has evolved comparative to, let's say, Europe or the US or other countries where it has also been parallelly or simultaneously been developing.
Yeah, look, I mean, I think we've got to perhaps go back to what you started out saying, which is Y2K, because round about that time, if you just think about what India and India's tech ecosystem was all about, you'll recall that it was all about the export of software. And so, quite frankly, we weren't so concerned about data protection type issues inside India. We were more concerned about the fact that we had this huge industry which was catering to outsourcing. Essentially, US, European companies were sending information to India for processing, and we needed to do it in compliance with all sorts of laws. And at that point in time, Europe was becoming increasingly sensitive about the idea of data protection. And so increasingly, there was pressure on Indian service providers to make sure that their services complied with UK law. This is before GDPR. GDPR, as you know, is the strong European regulation. But even before GDPR, Europe had a lot of the GDPR features in each country's regulation. And so our Indian ecosystem was getting requests to sort of say that, are your laws adequate to what Europe wants? And I think our first brush with data protection came from that. We realized that, we needed to set things up in India such that when European companies came looking, we could point to something. And so we made a small amendment to the IT Act, the Information Technology Act of 2000, to include this reference to data protection. And it was a very, very offhand reference. It's a sort of an amendment to the law, which then from which was derived some rules, 8 rules, and once again squeezed into whatever they could amend into the law without really rewriting the entire law. So it was a very, very basic kind of a data protection framework. Had the elements of what Europe wanted, but I don't think anyone really took it seriously because there was no regulator. To the best of my knowledge, no significant penalties were imposed. No one was called into question for their data protection practices. But I would say that if you want to look at the evolution of data protection in India, the time we really got serious about this was during the rollout of Aadhaar. Aadhaar, as we all know, is the digital identity program, and that really brought into sharp focus during the rollout and subsequently as more and more services got associated with the digital identity. That brought into sharp focus this concept of privacy, and most particularly the idea that everyone in India has a fundamental right to privacy. That, of course, is most sharp focus in relation to the government use of data, but equally by that time, there was a widespread proliferation of private sector use as well. And so there was this idea that, even for India, what so far we were looking at in relation to the export of services, we began to then see that as India becomes more and more digital, it's going to become relevant for India. And so during the Supreme Court case on the right to privacy, the government announced that it would create a committee to look into just the forming of a data protection law. Now, it's important that even though this is where everyone thinks this is the first draft that came out, the Justice Srikrishna draft, I have to say that, and you've read this in my book as well, Anthony, that well before that, while Aadhaar was being constructed, a earlier draft exists, and that is a draft that I had the opportunity to participate in preparing. And then there was, after that draft, there was also another committee that was set up, the Justice Shah Committee, that also looked into these things. And so actually the Justice Srikrishna committee is the third such attempt at doing something. And then since then we've had, at least 3 versions of the draft, starting with Justice Srikrishna's draft, then the draft of the ministry that was tabled before Parliament, the Joint Parliamentary Committee draft that was subsequently prepared and shared with the public. And then most recently, that draft was withdrawn and a new draft was submitted. That is the current draft that we are currently looking at. So if you want me to, in maybe 5 minutes, summarize the history of data protection in India, that would be a summary of the history of data protection.
Yes, very crisp. Thank you, Rahul. Justice Srikrishna, that brings me to kind of my next question, which is really, there's one of your podcasts, Ex Machina podcast, has an interview or a conversation with Justice Srikrishna. Very, very informative. I think a little more than an hour long, almost an hour and a half, or if I'm not mistaken. But for the benefit of our listeners on this webinar who haven't had the opportunity to go through the entire sort of podcast, could you share with us the experience of sort of having that conversation with somebody as learned as Justice Srikrishna, and more importantly, some nuggets or takeaways that you'd glean from the conversation with him?
First, I mean, I think nothing I can say would be a substitute for actually listening to the podcast. Not just because I make no money out of the podcast, so it's just a really interesting conversation with a really smart man, and it's not just about data protection. It's about how he became a judge. Really interesting story, because he had admission into the Institute of Science, and then he almost took it up as a dare, because his father said that he'd never be a lawyer or something like that. And just like I wouldn't say to spite him, but just to show him, prove to him that was not the case. He took it up and then ended up being a judge of the Supreme Court. So it's just a very, very interesting conversation, at least I found, with an extremely smart and erudite man. But just to focus on data protection, I mean, I think the conversation was an interesting look into how he thought about it, and how he thought about many of the issues. And you'll find that perhaps at one point in the conversation, we get into a bit of an argument. It's lots of people have told me after that was a real argument. It was, neither of you are pulling any punches. And I think that's sort of that's the reason why I would say it's really good to listen to the conversation. But he had some strong views about what needed to be in the law. And at some point in time, I sort of said that, look, this is too much of a burden for companies to bear. You've got to recognize that we have no experience of putting in place all of these things in our country. And to suddenly now immerse companies with no experience in a framework that requires as much compliance as Europe, which has had 30 years at that time to prepare for this, is too much. And his response to me is, that's the cost. That's the price of doing business in India, because in India, we are going to give that much importance to data protection. And we're going to give that much importance to the privacy and the rights of the data principle. And I think that, just to riff on that point, the idea of a data principle is a very Justice Srikrishna kind of a thing. He says that around the world, so just for context, around the world, the data protection laws are framed in the context of data subject. Data subjects are the persons who are the subject of the data protection law. And this is you and I, from whom data is collected. And then the other entity is the company, which is the data controller. This is the entity that controls the personal data of the individual. And in a very typically Justice Srikrishna way, he said, look, the last time I was a subject, that was of the Queen of England, and I am no one subject. So it will not be data subject. We will be called data principal, because we are the principal element of this entire legislation. And you, the company, will be the data fiduciary, because you have my data as a fiduciary. You hold it in trust. And so the way you behave with this data has to be the way a fiduciary behaves with it. And so in a very classic Justice Srikrishna way, he inverted it. And I know a lot of people look at this and say, this is a very innovative framing. This is a framing that is what we need for this current time. So the whole conversation is around things like that. I had the good fortune of spending a lot of time with Justice Srikrishna over, even during the drafting, because he was very generous to come to conferences and to engage with people, to just elicit information from the way people think. He was very clear not to let any information out as to what the committee was thinking about, but he was he engaged with a lot of people. And so in all of those sessions, I spent a fair bit of time with him to try and understand some of these things. And so you can feel that in the conversation, because I just sort of felt that we had a rapport. And so we could have a deep conversation. I wasn't necessarily holding back the way I would otherwise have to a formidable judge, as you no doubt know he is.
No, that's true, and I think the way he elevated data subject or to the data by simply changing the the terminology or nomenclature, it immediately, if that finds its way into a statute, you can immediately sort of see what is the difference that it makes to the way people treat the data principle, as well as the fact that the company that is managing or has the data is holding it in trust, and by virtue of calling them the fiduciary, immediately you've changed the entire dynamic of the relationship between the two parties. I think very, very smart play with words, right? Even when you're drafting statutes, I think it is very important how you define certain key terms, and I think that really comes out beautifully in the way Justice Srikrishna had wanted to bring it out.
And it's reflected in all the other drafts. So even today, even though we have a very different draft from what he drafted, two things have remained the same, and that is the data principle and the data fiduciary. So that concept is very much an Indian concept, India's contribution to the rest of the world. Unfortunately, I don't think the rest of the world is too entrenched in its ways to change the nomenclature. But India is a very large market, very large data market, and whatever they say when they come to India, when they're reaching the 1.4 billion people in this country, they can't call them data subjects. They have to call them data principles.
Definitely elevates us a little more than we would have otherwise been. All right. So, Rahul, and I'd love to chat a little bit more about Justice Srikrishna, but I'm keen to touch as many different topics in the course of the 45 minutes or time that we have today. So, shifting gears quickly, you've been part of the Chris Gopalakrishnan committee. We always hear about all of these committees that actually sit together and put out a draft and all of that. You've actually been part of one of those committees. What's that experience like? I mean, is it just a bunch of people sitting in a room talking until they get some points out on a draft, or can you tell us a little bit more about how that process works?
Well, for the I guess the most important thing was this took place during COVID, so none of us were in a room. We were all very much like this on Zoom screens and having conversations. So I think for the entire duration of my interaction on the committee, I didn't meet a single person in this sort of way that you described. But it is sort of like that. I think obviously it's a lot more structured, because if everyone just sits in a room and talks, no one will get things done. So I think the way it works is there's a lot of structure that the chairperson gives, and very much the chairperson has sort of a framework within which he or she would like to take the conversation forward, prepare the report. That very often comes from the terms of reference. But then I think on each of the points, if you cannot have a full and frank discussion around all the issues, then you're not really getting what the committee was set up for, which is to sort of get what everyone thinks about the issue. And I have to say that on the non-personal data, first of all, just to be completely clear, there's no country in the world that has come up with a framework like this. And so we didn't have very much to look at. The Justice Srikrishna committee had almost 30 years worth of jurisprudence to look at, because there were many countries around the world, there were many frameworks that people had used. Justice Srikrishna refers to the US model, the European model, and said that India is going to be a unique model, but at least he had the frame of reference. But the Chris Gopal Krishnan committee had no such frame of reference, because we were the first country that was going to look to a framework to do something with non-personal data. And so there was a lot of heated debate in the committee, and I think through that a lot of good ideas come up, and then it's an exercise of trying to find consensus, which we all go through in our professional lives, no matter what we're doing. I may have a very strong view, but that may not be the view that is eventually the view that is adopted, and we just need to find a way to get to consensus, which is respectful of all the different views, which also incorporates the views to the best extent possible, and then comes up with a coherent narrative for the entire report. So it was a very interesting process, and we don't have the report out in the public, but the report has been submitted. And I think that's largely due to the fact that we've got to just get this data protection law out. And then once we get the data protection law out, perhaps we can think about other things like the non-personal data idea. But I think there was a lot of good work that went into it. And I think it's certainly, that's another area where India can actually contribute to the global discourse.
So hopefully we'll actually get to see the government will make the report public maybe once the law is passed or what have you. I don't know. Do you have a sense of what the government's planning to do with it?
I mean, I sincerely hope so, but it could take shape in any one of many different ways. So I just hope that some of the ideas that are in the report can be translated either into a general law or just diffuse itself into many other data regulations that the government is thinking about. Because I think it is important that some of that work that's been done finds its way into the public domain, so everyone can take advantage of it.
Understood. Changing tracks a little bit, you've advised corporations on best practices, what's the way to structure policies and processes so as to ensure that you're sort of on the right side of the law, so to speak. Without naming any organizations, can you share with us some instances where things may have gone wrong, or you've seen or heard that happen, just more as an illustration of what not to do or what to watch out for?
Yeah, look, I mean, I think the thing that we hear the most of is instances where there have been data breaches. So, vast amounts of data, and then it leaks, and people get all in a tizzy saying, what's happened, what's my data, where's it gone, things like that. And I think, all of those are really serious, particularly when there's a vast amount of personal data that is significant. That is very serious. But if someone leaks your username and password for some food delivery app or something like that, I don't know, what would the whole world care about whether I like pepperoni pizza or margaritas, right? So that's all the influence, that's all that sort of data can influence. And I think that's not so much of a concern. But data breaches is just one very small aspect of data protection regulation. And I think the more serious consequences are when data is collected for a particular purpose and then used by the organization for a completely different purpose without consent. And we've seen those sorts of instances. So, for instance, as you said, without naming any names, there are instances where, and we see this happening more often than not with the sales team, because the sales team tends to be overzealous when it comes to trying to make a sale, and very often that translates into sort of just getting the telephone number of someone and reaching out to them and making a cold call. And very often the source from where they get this telephone number is perhaps suspect. It is someone who has not authorized the use of that mobile number for sales and marketing purposes. As you know, a lot of these modern systems for entry into companies have these very digital front ends where you provide your mobile number, you get an OTP. But in the process, you've actually left your mobile number with that company. And then if the sales department actually gets hold of that number and then starts calling you and selling things to you, that's clearly an unauthorized use of your mobile number, because you only provided your mobile number for the purposes of entry, not to be sold some new product or upsold some new product. Now, at this present point in time, because we don't have either a strong data protection law, and more importantly, we don't have a regulator, a lot of these practices go by unremarked. I think some of us get irritated by it, but quite frankly, we've got nothing that we can do about it. And when the data protection law comes into force, it's exactly these sorts of things that the regulator will start cracking down on. And so companies are going to need to think very carefully about their process from top to bottom, because a company will be liable for this. It could be some overzealous sales employee who took these telephone numbers and decided to start cold calling them. But it is a company that is responsible, because the company's processes are such that the data that it collected as a company was being used by someone else in the company without, for a purpose that was not authorized in relation to the collection. And this is just one example, but there are many, many examples. It could be as simple as you collected this for a specific purpose, for the provision of a particular service that the company is providing, and then the sales team decided to upsell another product. Now, if you didn't get consent for that upselling, then that could also be a violation of the data protection regulation. So I think these are the sorts of things that companies are going to need to start to think about, because if you take a look at the framework of the law, all of these things are punishable. There could be quite significant fines, and as you've seen around the world, data protection regulation is assuming quite a serious regulation, because fines that are being imposed on companies are quite serious.
I think that a lot of sales and marketing professionals are already beginning to wonder how they're going to live in this new world, because I think what you've just described is the old-fashioned way of closing a sale, right? You get a lead, and then you follow up relentlessly until you get them to either buy or block your number. But so it is clear that if at all there is a small window for sales professionals and marketing professionals to use data, it is now, before the law is passed, because clearly once the law is passed, then for example, organizations buy data, right? Leads of let's say lawyers or HR professionals or what have you. So all of that is something that you can't just buy data and then use that for sales and marketing purposes, right? I mean, post let's say the law being passed.
Look, I mean, so if you process personal information, you have to have some grounds for processing, and the easiest ground for processing, or the easiest way to get around this, is to get consent. You can use information for emergency purposes, like, for instance, personal information about your health, that you have an allergy to sulfur or something like that. Right. A health professional could use when you're caught in an accident and they need to know whether they have to administer a drug to you. They need to know all that information. So there are grounds for processing that are different from consent, but I would say the vast majority of processing takes place on consent. And if you bought personal data from some third party, you do not have the consent of the person to whom that personal data pertains to actually use that data. And so, you say that sales professionals have to change the way they're doing. They're performing their sales function, but I have to tell you that there are sales professionals all over the world, and India is one of the few countries where we don't have a law at this point in time. Europe, US, everywhere you've got sales professionals, and everywhere there are laws that are increasingly becoming stricter on the use of data without consent, or the use of data for purposes that have not been expressly consented to. And so the only positive spin I would put on this is that if sales professionals around the world can actually operate successfully within these constraints, I see no reason why Indian sales professionals can't also do that. Of course, it's easier to do this, but once the law comes down and says that you can no longer do this, it doesn't mean that that's the end of the world. There are many other ways in which you can carry out your function.
I'm confident that sales professionals in India will figure a way around this for sure. All right. So Rahul, as we move towards possibly having a law that governs, that protects, personal data in India, right? It looks like we are going to find ourselves with a law sometime this year. Either it'll probably be introduced in the monsoon session, but might find its way as an act or a statute sometime by the end of this year, right? I mean, is that the sense that you're getting as well?
So that's what the minister has promised. I'm predicting a law for now almost over a decade now. So my predictions, people have stopped relying on, but I assure them that this is the closest I've seen to a law. So hopefully that is true.
It's a bit like the entry of foreign lawyers into India. I mean, I think that's something that.
Oh, please! I hope it's not the same.
It's not that long.
For longer than a decade.
All right. So, in light of the fact that we're likely to see a law very soon, what advice would you give corporates? Just maybe 3 points that you can think of that they can start preparing for. I'm sure many of the large corporations are already taking advice from you, but for the others, what would you say? Common sense, 3 or 4 pointers or tips that you want to leave for them to enable them to prepare for the new world post the data protection statute coming into place.
Yeah, look, I mean, I think understanding what is in store for them, understanding what the law has, understanding the provisions and the principles that are contained in the law is very important. So, it's nothing unusual. It's the same privacy principles that apply around the world. And so just being aware of what that entails, what those are, and then also understanding how those would apply to their particular business is extremely important. And this is, of course, we're going to have a new regulator, we're going to have a new law, but the principles have been used, I'm going to say now, for over 30 years, maybe even 40 years around the world. And so there's a lot of precedent around the world. And I think that there's every likelihood that the international, whatever is being used around the world, the principles and precedents will be applied by the regulator in the Indian context. So I think that's the first step. I think the second step is really doing, as the example that I gave around sales professionals. I think it's really important to do detailed and in-depth training and perhaps retraining of your staff, particularly those that engage with personal data, because everyone's used to doing things in a particular way, and they're going to find that some of the things that is the only way they've ever done, they absolutely cannot do. But it, as you said, we will find a way around it. It's just a question of being aware that these are the things that you can't do, so that you in the way in which you do your work and the things you want to achieve can find a different way to do things. And I think this is perhaps the 2 most important things that you need to do. The third, of course, is you're going to need to create within your organization some sort of a privacy organization. You need to have a department that is looking into these sorts of things. And I don't want to comment too much on this, because whatever the final shape of the law is will dictate how that works. But in addition to all the other compliance functions that you have, you will also now have a compliance function that is related to data protection. And the simple example of this is, if you collect someone's information, that someone has the right to come to you and say, do you have any information of mine? And if the answer is yes, what are you using it for? Now, if someone asks you the question, you should have the mechanisms within your company to be able to give them an answer, yes or no. And if your answer is no, it should be backed by the fact that in actual fact, you have no information about them. Because if at a later point in time, it's discovered that you said no, but you actually still do have information, then you'd be in breach of the regulation. So these are non-trivial things. And I think entire company organizational workflows perhaps will need to be redesigned in order for you to be able to provide answers to these questions, or to be able to comply with the obligations that are contained in this new law. And we've for so long been operating without a law that I think we will find that as we take an internal look at our various processes, that we are lacking in many ways. And I think this third step is actually something that companies will really need to bend their back in order to get right by the time the law comes out.
Possibly training and sensitization as well, in the sense of you're only as strong as your weakest link, right? So it makes sense to have all your employees fully trained and aware on what is, why is data. It's so important to protect data as a corporation, as an organization, not just individually, but also when you're an employee in an organization. Why is it important that you ensure that data is kept safe and within the parameters of whatever it is that the law states?
Absolutely. And look, I gave the example of a sales professional, but it's everywhere, right? So anyone in the organization has access to this information, and anyone in the organization could innocently use it for something else when they haven't been trained to keep in mind that when you use personal information, you've got to either have consent or something like that.
Understood. Okay. So Rahul, we're kind of now going to start winding down our discussion. What is your view of, sort of where we are headed, right? Because of the rapid pace at which technology is changing and evolving. You've got things like, AI, ML, Chat GPT, things, I guess, the way pace at which technology is changing, I'm not even sure if any of us can accurately foresee what lies ahead. In light of where where technology is headed, what do you think? How do you think the regulatory framework should look like, and where do you think we're headed in terms of what should corporates be doing? I know you've already mentioned a few points, but to ensure that we are future ready, so to speak, is there anything that you want to leave as sort of words of wisdom for corporates?
Look, I feel that we're at an inflection point, because I think the technologies that are coming are so radically different from the technologies that have brought us up to this point that it's almost impossible to say which direction it's going to go. And AI, ML, and large language models, and all the brilliant things that we're seeing with generative AI, which is where we are right now, are really pushing the boundaries of what we have always believed is possible, and also the boundaries of what we think that technology, that regulation can actually control. So just take privacy, for example. These large language models have basically ingested information from all over the internet. Now, we have no idea how much of that information is personal. As we use these models more and more, companies will start to upload information onto the internet, which is perhaps sensitive. And then that information is being ingested by third parties, and questions will arise as to, how did you give my personal information to some third party large language model, and what did they do with that information? So we're going to start facing very, very different questions than what we've faced so far. But at the same time, the benefits from this technology are so remarkable that it's impossible to ignore them. So as much as they raise very, very challenging privacy questions, we still have to find some way to, figure out how to take advantage of it. Because I think that if we don't take advantage of these technologies, we're going to be left behind. So for all of us, professionals within companies, lawyers, privacy professionals, this next period of time, I'm going to say as short as 5 years, is actually going to be quite transformative. We're going to have to be thinking on our feet, because I think regulation will evolve quickly, technology will certainly evolve quickly, and there will be changes that we're going to need to dynamically adapt to. So for a while, I've been saying that we need to be looking at regulating this sector using agile, principle-based regulation. We need to be ready to change and respond to harms that are caused, so that we don't allow society at large to be harmed by these technologies, but at the same time, we allow them to flourish to the extent possible to give us all that we need out of these technologies.
Terrific. So I know that, Rahul, people keep talking about AI, ML eating into jobs, but I feel like one of the benefits of the data protection regime that we're looking at is probably the emergence of a new breed of compliance specialists, right? In terms of those who are focused on data protection, not just lawyers, but a whole breed of compliance specialists. What are your thoughts on that? Do you see that there's likely to be a significant, that's an area of, a practice area for many? Is that something that's likely to generate a lot of jobs?
I think there is going to be, as I said, a new compliance vertical, and that would be around data protection. I think what companies under the regime as described need to do is not something that the existing compliance organization will be able to deal with. One, because it is specialized. So you're going to need to find people who have specialized expertise. And two, because perhaps even the regulation, and we'll see what the regulator has to say, will demand it. Around the world, this is actually a very different organization. It doesn't report up to the compliance function, but often reports directly to the board. So there are new ways in which organizations are going to need to put these teams together. And as we started out saying, technology is so cross-cutting that even the most brick-and-mortar business has technology somewhere. And so even the most brick-and-mortar business is going to need to put in place an organization like this. So let's not just think that this is only for the social media companies or only for the software companies. Every single company in the country is going to need to have some sort of a privacy organization because that's what the law will demand. And so there's going to be a need for privacy professionals across the length and breadth of the country. Now, you frame this in the context of AI and ML, so I feel I must push back, because who knows whether AI and ML are going to eat into the jobs of the compliance professionals as well. Maybe we're going to find some AI ML solution to comply with data protection law. I think, being a technology lawyer for 20 years, the one thing I've learned to say is never say never. Technology has a way of surprising me, no matter how astute my predictions are. So I'm not going to say that AI and ML is not going to result in a loss of jobs. All I will say is that at least history has shown that even if there is a loss of jobs, it's just that it's not so much a loss as a shift. That the jobs that will exist in the future are different from the jobs that existed in the past. And no matter how many time-saving technologies we've developed, we're busier now than we've been before. And so I don't think technology destroys jobs at all. I think those of us who are fortunate enough to keep pushing and staying at the edge of technology will always have a job.
So having the right skill is more important, I guess, and staying relevant and being skilled is, I mean, as long as you have the right skills, you'll survive no matter what. And
as long as you're willing to reskill yourself. Look, I mean, I think that's certainly the most important thing. I think it actually takes a lot to reskill yourself. I look back, I've been a lawyer for 25 years and I feel that, all the skills that I had is now being called into question because of all the things that GPT and all of these generative AI can do. And I have I like to think I have another 20 years of my career left. So I jolly well reskill myself if I want to remain relevant for the next 20 years. And I think that's sort of the attitude that everyone has to take.
Reskill to be relevant. Agreed. Fair enough. All right. I think we're almost at the end. So I just wanted to, before I wind up, on a note of, we have heard that you're not only an expert in data protection, but also a skilled culinary enthusiast. Is there a favorite dish or something that you like doing that you'd like to talk about that you can share with us?
Look, I mean, I think this is like the rockstar data protection. I like to I like to cook. I wouldn't say I'm skilled or culinary, but I enjoy putting stuff together. So is there a favorite dish? I wouldn't say there is any. As you can see from how engaged I get, I like the more technically challenging dishes. And so if you ask me to do a dal chawal, I'm not very good at it, but you want to do something which involves some chemistry and things like that, and of course I'll absolutely try. It may not be very edible or very interesting, but I would certainly try my hand.
All right, very good. That's good to know. But you are a very, very serious photographer, right? I mean, that is there's a lot of stuff that you've put out there from your travels. These are all from your recent trip, is it? Can you tell us a little bit about these?
Yeah, so this is from Africa. I was there a couple of weeks ago. Once again, I'm serious in the sense that I do go out and do these trips, but I'm by no means a professional. This is just for fun. I like going
these are
out,
great. I mean, these are just terrific. These are really very, very good. The elephant in the field of gold. That's a really nice one.
It gives me a very Ukraine feel right now. But yeah, there's this one place in Africa which for 1 month in the year, you'll find these gorgeous fields of yellow flowers, and you have to be there at that time of the year. And if you're really lucky, an elephant will walk into the field of gold, and you have this beautiful backdrop behind, which is the sides of a now extinct volcano. And so it's really a very special kind of a place. So yeah, I mean, I enjoy. This is how I sort of unwind. I really enjoy being out there. One, being out with nature, and two, just trying to capture these sorts of things. It's just very different from my day-to-day, my daily life.
Thank you, Rahul. These are terrific, and I realize that you've posted a fair bit on your Twitter handle as well. So those of you who want to actually see more of Rahul's pictures, check out his Twitter handle. I don't have it offhand, but Rahul, if you can share it with everybody here, I think there's
just my last name, Martin, M-A-T-T.
Just last name.
That's it. Yep.
These are some terrific photographs. All right. So before we take questions, I just also wanted to make an announcement. We are Rainmakers also we have created a toolkit for individuals and organizations who want to know a little bit more about how to navigate the data protection and privacy compliance world. So it's like a toolkit with a checklist of things that you can just go through. It's a short document, I think not more than 4 or 5 pages. It'll for all of you who are participating or on this webinar, you'll get it in your inbox soon after this webinar. And for those who want it, it can be downloaded off the Rainmaker website. So it's fairly informative. So if you'd like to know more about what we discussed today, but more in a sort of a checklist or a toolkit format, then go ahead and sort of download this toolkit. I think you'll find it very, very useful. All right. So we have maybe 5 or 7 minutes tops. There are some questions. Let me see if we can take up some questions for Rahul. Well, there's one. Okay, so Hemant Tiwari is asking, how can data protection regulations such as GDPR impact businesses and individuals? It's a fairly, I mean, I think we could take another hour to probably discuss
No,
that.
I mean,
Hemant.
look, I think let me just very quickly say that with GDPR, for example, it has extraterritorial applications, and I think that's the reason why companies need to be concerned about it. Because if you have anything to do with Europe in the nature of your business, if you're processing information of some European customer or anything like GDPR would apply to you, and so. Even if you're sitting here in India, you have to comply with those laws because sort of that's the nature of the regulation. So I think even today we have to remain cognizant of the fact that we are obliged under the regulations of other countries to comply with their law, and I think that's something that most companies know, but perhaps. Not in as much detail, and I think that's important.
Thanks, Rahul. We have another question. Recently, Italy has banned ChatGPT over the collection of sensitive data without permission. What do you think will be India's stance once the DPDP bill is passed and enforced?
So, I mean, on the Garante, which is the Italian DPA's ban, they sort of suspended it for a little while. My understanding is that GPT is back live in Italy because they agreed with the Garante's conditions as to what needs to be done with data. Now, this is what I said. I said, in response to your question, Anthony, that there are these sorts of issues that will come up because the technology is so revolutionary. As far as India is concerned, I sincerely hope we don't, because I think it's important to recognize that there are benefits for GPT. But there are consequential harms and trade-offs, and I think it's really important to not just ban, but to sort of understand how this would apply in the context of personal data, and also the specific framework that India has, and certainly prevent harms from happening, but not just cut things off at the knees, as it were. Very often, it's not ChatGPT that's at fault, but service providers that leverage ChatGPT or GPT more generally in the backend that collect information from you and then pass it on to GPT for processing. Now, in these circumstances, it's not OpenAI that is at fault. It would be the entity that's actually collected this information and passed it on. And so there are these sorts of nuances, I think, that we're going to need to get into before we can decide one way or the other.
Agreed. Mayank is asking, what are the skills for lawyers which they can develop, especially in technology? That's, again, a very broad question, I guess.
Yeah, but look, I mean, I think at least and this is my very personal view, I think if you want to be a legal advisor to technology companies, I would say spend more time understanding technology. Because as a lawyer, you've been trained to understand law, but lawyers are not so much trained to understand technology. And if you are only going to be providing legal advice to technology companies and not legal advice that fully applies to the technology that they are asking you questions on, you're not going to be doing justice to what they want and also what a technology lawyer ought to be giving. And I find that the law side of it, most of us are focused on, but the technology side of it is actually not that easy. And so I would strongly suggest if you're thinking of this as a career, that you spend more than enough time actually reading up on technology, understanding the way technology works. I mean, almost 10 years ago, before crypto was this big thing that it is now, I had my team read Satoshi Nakamoto's original paper with all the maths and understand it, because I said you can't be advising on crypto and Bitcoin unless you know how this whole thing works, and that's sort of the level that I think you need to get into of the technology.
How well did your team do in understanding how crypto worked? Because I'm sure lawyers may have struggled.
we've got the best tech practice in the country. I mean, sometimes when the team talks, even among other teams in the firm, it's just gibberish, because they're talking Greek and Latin to everyone else, as everyone else is to me. I mean, if you ask me how all the nuances of capital markets, so I have no clue. But they do know. I mean, this is almost now a gating criteria. If you don't understand the way Bitcoin works, it's difficult to function in our team.
Agreed. We have another question, which I'm going to read it out, and then you can choose to answer how you'd like, because I appreciate that this may contain names or references of customers. So you can also refuse to answer it if you'd like. What do you need to study and specialize in and stay on top of to be in a team that handles data in the right way for an organization? And second part of the question is, are companies like Meta or Facebook, Amazon, or Microsoft incompetent of protecting their data despite strong laws in the US, or is it that they're just careless? Yeah, I mean.
Yeah, so look, I think the big tech companies are certainly pilloried for a lot of the problems that we're currently facing. And in some instances, yes, I think they are to blame. But at least my experience of working with them is that very often they have to find solutions to almost impossible problems, because the trade-offs are so challenging that no matter which way you decide, no matter what you choose to do, you're going to cause some harm or the other. And so it's literally between a rock and a hard place. If you say yes, you're in trouble. If you say no, you're in trouble. And so
right.
I think we've got to recognize, and look, all of your companies are going to be faced with those sorts of situations fairly soon. So as you try and navigate those areas, I think you'll find that it is not as easy as it seems. So I would just say that let's not underestimate how challenging and how difficult this whole process is. It's complicated at scale, because if you're just dealing with I don't know, even 100,000 customers, that's a lot easier than dealing with 2 billion customers on the platform. At that scale, there is just absolutely no answer that is the right answer. So yeah, I mean, I would say that I think things could be done better, certainly. But at scale, it's really hard. And I think we've got to judge companies on how well they come back from instances, because even the people on this call, something's going to happen. Some data breach is going to happen. Now, how do you respond in that situation? Do you inform your customers as quickly as you can? Do you inform them the moment you have credible information so that you don't cause panic? Do you tell them exactly what they need to know and not scare them even more by giving them incomplete information? When do you inform them? Look, these are all very, very difficult questions, and I'm it's just almost it's almost sad that we don't have the experience of dealing with this yet in the country. But we really need to, because these are things that are gonna happen. India is digitizing faster than any other country on the planet, and so all of these issues are gonna come to us and hit us like a truck, because we've got no experience at dealing with it in the way the West slowly, gradually had experience.
Fair enough, and I think some of the lessons will probably be learned the hard way. There is probably no way around it. Hopefully it will not be too rough for corporate India or for individuals in India before we get to the place where Europe has already reached. All right. I'm cognizant of time. Rahul, there are about 4 or 5 questions more, but would you be able to take a couple, maybe 2 before we wind up, or would you like
maybe like one more question, and if you can combine the 2 into one, I'll answer one shot.
All right, so I'm going to try and combine the two into one. So there's one. Firstly, I enjoyed reading the latest blog on trucking. We really need to pay more attention to the sector. And second, my question is, do you think policymakers and regulators? So the question really is, what role do you think policymakers and regulators can play in balancing, safeguarding data privacy, and promoting innovation and technological advances? Part one. Part two is, what measures should be taken to secure personal or business data stored in the cloud? With that, we can close the questions.
So look, I mean, I think this is one of the hardest challenges, right? So balancing whatever the policy objectives are with the need to promote, because quite frankly, technology is all about pushing the boundaries of what is possible. And it's only when you push the boundaries of what is possible that you'll start to get really the magical innovation. And so it's a tough line, tough balancing act that regulators have to do to balance these two. But yeah, certainly they have to. And I think the only way to do it is to really be agile about it, respond quickly when you see the harm, but at the same time just allow these innovations and regulations to take place. And then on the cloud, look, I think the cloud is a reality that none of us can ignore. I think the time has passed when the protection of personal data, we believe that we have a higher level of protection when we store them on premises as opposed to in the cloud. Today, I think most people believe that it's probably safer to store it on the cloud, where there are professionals that are looking to ensure that the data is safeguarded while it's on the cloud, as opposed to in your premises where it's subject to physical attack and things like that. Nevertheless, you have to, because it's your responsibility if there's a breach in the cloud. Over and above what your cloud provider has put in place, you've got to have the correct systems in place to secure that data when it's on the cloud. So I would just the reason for that layered response is that I think that we've got to now embrace the cloud a little bit more, but obviously not blindly, because that would be dangerous. Put in place the adequate level of protection for anything that you store in the cloud for where it is.
Terrific. So if you use any of the regular, the big tech cloud storage solutions, you should mostly be safe and fine. Would that be a fair way to?
Look, I mean, I don't like to generalize. I think there have been many instances where there have been breaches even there. I think, of course, if you're in a one of the large providers, I think you also become a bit of a honeypot. If people want to find big stores of data, they'll go to the big providers, and if they've got a backdoor in, they will find a way in. So that's the downside of it. But having said that, these are really big companies that currently do protect vast amounts of data for some of the largest and most highly regulated companies in the world. So I would imagine that that would be your best bet if you're sort of just starting out and trying to figure out how to do this.
Wonderful. Thank you, Rahul. Thank you so much. Also, thank you for taking the extra 10 minutes. I'm aware that you have another webinar coming up in 20 minutes. So really appreciate the time that you've taken to kind of chat with us about these issues. I feel like this is just the first of many that we'll do together, because we can go deeper and deeper into the subject as we go along. But of course, subject to the time that you can spare. So thanks once again. This has been wonderful. Really appreciate it. And I look forward to hopefully having more sessions like this one in the future.
My pleasure. Thanks for organizing it. I think this is important work you're doing at an important time. Thank you.
Thank you very much.